Thank you, Ms. Nkabayi. You sit up. I hope you're awake.
Not really, my lord.
Where's your sense of humor? 19 minutes past 3 and 54 seconds. I got your heads. I read it. It's fine. I read all your cases. But thank you. Just for the record, in further documentation, the case number that you have might be wrong. It could be in the process as things got to the High Court. But for any process, the correct case number is CC19 of 2024.
Which one is that, my lord?
Our case number.
Oh, this one.
You had it as 24/4
Okay.
of 2024. That's just for the record. Thank you. I read your heads. I also looked at the list of cases that you gave us yesterday. There was one that I couldn't find. Some of them, the citations are slightly wrong, but don't be concerned about that. We found them all. The cases that you referred to in your heads, I had a brief look at some of them this morning. Nothing changes. So I think for structure, I don't know how you plan to do it, whether you're going to just take me through the heads, because a lot of the issues have been argued already. We can skip over that, and we can hone in just on the main issues. You've set out the law insofar as it relates to the owners. You've set out the law insofar as it relates to how to evaluate the evidence of a single witness, and more particularly a 204 witness, coupled with Van der Meiden and those cases, and Tom, and then in T, there were actually two T's. In the second T, Plasker J, as he then was, refers to the previous one, and so I've looked at both of them, and the quotation that you've added in. So all of those are right. We don't have to repeat it, unless, of course, you want to go through your heads. I'm going to give you leeway to shoot. And I'm going to try not to interrupt you. Because we're short of time today.
Thank you, my lord.
I need to finish the argument today. I want to make it clear we're going to sit until we're done with the reply by the state. And the reason for that is I will have to, when we leave here this afternoon, go and knuckle down, maybe through the night and tomorrow and through the night, to be ready on Friday morning. So I need your assistance. Thank you. Thank you, Ms. Nkabayi.
Thank you, my lord. My lord, I am Ms. Nkabayi from Nkabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judicial instructions. My lord, yesterday, or before I go there, my lord, when the news about Joshlin's disappearance broke, the whole country came to a standstill. Not only South Africa, my lord, even the global village. But the unfortunate part in this matter is that the investigation didn't do justice in this matter. Mostly, my lord, poor investigations, they have a tendency of leading to unlawful arrest resulting to malicious prosecutions. In this matter, the state has a duty, it has an onus to discharge its case beyond reasonable doubt. I have listened to my learned colleague yesterday from early as 8:30, including 1 o'clock. She didn't come closer to prove their case beyond reasonable doubt. There's no evidence before this court that my client, Mr. Van Ryn, did unlawfully and intentionally deprive Joshlin of her freedom of movement. There is no evidence before this court that my client, Mr. Van Ryn, delivered Joshlin to anyone for any amount. My learned colleagues were noticing that they failed to discharge the onus. They are pleading with this court to convict Mr. Van Ryn on speculation. Speculation drawn from the evidence of a 204. My Lord, I would like to pause and look at the person of this 204 before even she was arrested. She testified before this court that she was taken to Langaban. While in Langaban, they were taken to an open space where they were assaulted severely. And while they were assaulted, they were asked about the disappearance of Joshlin. She testified that the people who were assaulting them, it was herself and Ayanda. Ayanda is known in this court as her partner. They were assaulted by people who were covering themselves with barricade. They were assaulted, they were taken back to Langaban. From Langaban, they were taken to police station. At the police station, her partner was released, but after some time, she was arrested. She was arrested on the 13th of March, 2024. We've got this 204 after being, or during the assault or the torture. She doesn't confess to the people who were torturing her. We've got this 204 who's arrested on the 13th of March. She's appearing in court. She doesn't confess. There's something I know about this offense. I've got information that can help the state. She's quiet. We've got March 2024, April 2024, June, May 2024, June, July, August, September, October. October 21st, 2024. The same person who was tortured 7 months before is saying now, I can confess. That and that alone is saying a lot about this 204. Let's bring her before court. Before she was brought before court, she was taken before Sergeant Sikhobe for a statement. Sergeant Sikhobe is such a polished police officer. She impressed me when she was administrating an oath to Laurentia Lombard. She told the court that I am fluent in Afrikaans. We spoke in Afrikaans. But I wrote my statement in English, but she understood everything. After I wrote my statement, I read it back to her. I asked her, do you understand? The answer was yes. She took an extra mile further by asking her, do you want to add anything? Do you want me to correct anything in your statement? The answer was no. After that, an oath was administered. She said, even though she was twitching her arms, but she could understand. While I was taking her statement, this is a testimony of Sergeant Sohobe, she made me to believe that what she was telling me is the truth. Now, when confronted under cross-examination, no, I was scared. Scared of what? Sergeant Sohobe is more or less of her age. Is young. I was scared. Maybe I had a relapse of drugs. So that's why I lied. What is surprising me worse, my Lord, is that she knew she was lying, but she continued. Like, that's not even a lie. She fooled an officer. That's the 204 we're having before this court. As if that was not enough. Now, she went to give a confession. She didn't stop. She's referring to the officer who was taking her confession as a woman with the gray hair. I suspect she looked older than Sohobe. She was supposed to respect that officer. These people are trained. These are the pride of our country, law enforcement officers. We've got a 204 for the second time who is lying before an officer. In court, her confession was amended by the state. Which value do we attach to that confession? With its lies from the owner, with its amendment by the prosecutor. As if that was not enough. Now she's appearing before Captain Lombard. She doesn't stop lying.
I'm with you.
When 204 statement was brought before this court, it didn't stand the test of cross-examination. There were many lies, contradictions, inconsistencies. Now, someone will, if we take the defense when she first appeared before Sergeant Sohobe that she was relapsing from drugs, was she even relapsing from drugs after 7 months on the 21st of October when she lied? Was she still relapsing when she lied before Captain Serious? No. I asked her, do you believe in God? Were you brought up in a godly family? He said, yes. My parents told me about God. I asked her, do you know the consequences of lying? She said, yes. She even said, even at school, my teachers told me about God. They told me about the consequences of lying. But she didn't stop lying. We cross-examined her, 2 of us. She lied to my learned colleague for Mr. Apollis. She lied to me. She lied to my learned colleague for Miss Kelly Smith. Now, surprisingly, the state is convincing the court. Now that I have failed to prove the elements of kidnapping, trafficking, please, let us convict the 3 on speculation. Wow. Where is that coming from? Speculation? We're drawing the inference from the evidence that was led by 204. Which 204? the one who lied uncontrollably, the one who fooled 3 police officers. Now let's go to these speculations. When she was giving evidence, my learned colleague asked her a leading question: who were present in the discussion? 204 has never mentioned anything about a discussion, but my learned colleague asked her, who were present in the meeting? I knew discussion. I knew that word discussion, where it was going to. I knew it was going to concoct the principle of common peoples. She mentioned 6 people who were present in the meeting. Another surprise, my lord. In that list of 6 people, she mentioned Joshlin, she mentioned Requeen. A follow-up question, very fast follow-up question was, where was Joshlin? Where was Requeen? Now he's placing them in different places. Requeen was in his bedroom, Joshlin was playing outside. I noticed that discrepancy. I waited for my time for cross-examination. But unfortunately, there was a ruling that I cannot put questions on that piece of evidence. I knew that piece of evidence is going to take us to the principle of common peoples. My lord, I object strongly. The state is not going to come and say there was a discussion. The state is not going to come and say there was a plan. The state is not going to come and say, yes, discussion, meeting, or plan. The state has to unpack and break down the discussion. In the discussion or meeting or plan, what was my client's role? What were his ideas? What was his input? Who was the chairman of the meeting? Where are the minutes of the meeting? We're not going to allow a state to come and thumbsuck meeting plan without the basis. I will argue that. The meeting, the plan, the discussions are unfounded and they're baseless. And the state cannot cry common peoples without first proving the elements of this of the main charges beyond reasonable doubt. We're not going to have a common purpose. It's a common purpose for what? Common purpose to do what? My client didn't deliver Joshlin. They didn't prove that. They didn't prove the intent. They didn't prove unlawfulness. They cannot. Another issue. My learned colleague argues yesterday that there was an act. Who acted? When? With who? When you traffic, you don't traffic alone. There's the other person. Where was this act? With who? Silent. Their conduct. Whose conduct? My client's conduct that day was his conduct even the other day previously. Did the state know how did my client conduct himself before the 19th? Which conduct are they referring to? My client on the 19th of February was selling the microwave. When did it become a crime in South Africa to sell a microwave? When did it become a crime in South Africa to visit your friend? I will argue that that was a common purpose to sell a microwave, not common purpose to kidnap or to traffic anyone. My learned colleague argued that Joshlin has been delivered. And she has been delivered for the purpose of exploitation for slavery. By who? Where? Who are the exploiters who are exploiting Joshlin? We want to know. In which place? She has to tell this court. She didn't. For 4 hours, 30 minutes, I was listening patiently for the state to prove its case beyond reasonable doubt. No compelling evidence before this court, no strong evidence before this court suggesting that my client committed an offense of trafficking in person, kidnapping, and all, any conspiracy. I will refer this court to those cases. The court said I cannot, there's no need for me to refer to them. Now the point I wanted to make, my Lord, is the point I wanted to make, this onus has not shifted. This onus is still upon the state. My client has no duty to prove his innocence. He has no duty to do that. The duty is upon the state. The duty that they've run away from. They know why. Now coming to my client, on the 4th of March 2024. Where was my client on the 4th of March 2024? On the 4th of March 2024, my client was at Vredenburg Saldhana hiking spot. He was with his cousin's boyfriend. He's hiking from Vredenburg to Saldhana. It was in the afternoon. While he's hiking, he was taken by the police. They never told him, they never introduced themselves to them. We are the police officers. We are looking for you. We are looking for you because you are a suspect in this case. Arbitrarily, they infringed his right to human dignity. He has a right, constitutional right to be treated with dignity, a right to be treated with respect. That right applies to anyone. You are educated, you are not educated, you are rich, you are poor. It applies to every individual person. I will argue that Section 10 of our Constitution, that gives my client rights to be treated with human dignity, was infringed by the police who took him at the hiking spot. I will refer this court to the case of Mahlangu.
Which one? Is it one of the cases that you sent me?
My Lord?
Is it one of the cases that you sent us?
Yes, my Lord.
Mahlangu.
Is J.E. Mahlangu? IT Mailela?
It's not one of the cases that we've uploaded, but if you give me the name of the case, I'll find it quickly.
Can I show the court just the front page? Maybe we'll quickly get it.
It's not one of the cases, but I'll quickly find it. Yes, it's the Constitutional Court case of Mahlangu versus the Minister of Police.
Yes, my lord.
2021, SABC, page 10. Yeah, what about it?
My lord, I would refer this court to paragraph 27 of the case.
Well, first tell me what was this case about in the Constitutional Court?
This case was about it covers two things. It was about the confession. I'm not going to concentrate on that. And it was about the infringement of Mr. Mahlangu's rights, my lord.
This was a case that dealt with the damages.
Yes, my lord, at the end, yes.
Following from
yes, my lord.
An unlawful arrest and detention.
Yes, my lord.
You want to take me to paragraph?
Paragraph 27, my lord.
Mm-hmm.
The unlawful deprivation of liberty with its accompanying infringement of the right to human dignity has always been regarded as a particularly grave wrong and a serious inroad into the freedom and rights of a person. There's a reference in that paragraph, my lord, to the case of Tandanani. I don't have that case of Tandanani.
Well, it's Tandani versus Minister of Law and Order, 1991, 1 SA 702, Eastern Cape.
In that footnote, yes, my lord.
And the other references is to Peterson versus Minister of Safety and Security in RF, which is a well-known appellate division case on delict. RF versus Minister van Politie, 1977, 2 SA 900.
Thank you, my lord.
And there's a sub-reference to another decision of the old NPD, as it then was, in May versus Union Government.
Thank you, my lord.
Yes, we can go back there if you want to,
okay.
to paragraph 27.
Thank you, my lord. In Tandanani, the court said that sight must not be lost of the fact that the liberty of the individual is one of the fundamental rights of a person in a free society, which should be jealously guarded at all times. And there is duty on our courts to preserve this right against infringement. Unlawful arrest and detention constitute a serious inroad into the freedom and the rights of an individual. My lord, the state didn't call this police who took my client from the hiking spot to come and testify. From there, he was taken to Jacobs Bay Beach, where he was further tortured. I will argue, my lord, that additional to Section 10, a right to be treated with human dignity, his rights in Section 12, 1A, and in Section 12, 1D, and in Section 12, 1E were also violated, my lord. Section 12(1)(d), my lord, is the right not to be tortured in any way. My client, and at Jacobs Bay Beach, he was tortured in the following ways. And this piece of evidence remains undisputed. The police who tortured my client, they took him to sea border. They are known, but they were never called. I'm not going to repeat how he was tortured. The court is aware. The third right, it's not the third, the fourth right that was violated is 12(1)(e), constitutional right not to be tortured or treated or punished in a cruel, inhuman, or degrading way. This started from Jacobs Bay Beach until sea border offices. I'm not going to repeat what took place in sea border offices. It is on record. But I would like to refer this court to the matter of Khoza.
Of?
Khoza, my lord. Khoza Mpepu. It's known as Khoza judgment.
Also not one of those that you gave us. So give me the... Yes, it's not one of the lists that you gave us yesterday, but I have the case open, and yes.
Thank you, my lord. Khoza is a matter where during COVID, our soldiers beat Mr. Khoza. They tortured him. He died. They threw his liquor outside. Summarily, those are the facts of this matter. I would like to take this court to paragraph 8 of this matter of Khoza, my lord.
Now, before we go there, what was the case about? Because remember, if we need to find whether it's a ratio decidendi or whether it's obiter remarks made by the judge to determine how I deal with it. So this is the well-known case of where the gentleman went through a lot of trauma at the beginning of the lockdown.
Yes, my lord.
So the relief that was sought in that case was declaratory relief. And it's set out in paragraph, the relief is quoted in paragraph 23 of the judgment. And I'm going down. Was this matter litigated further after this judgment?
I'm not sure, my lord.
Have you checked? I'm going to the ultimate order that was granted. The order that was granted was a declaration in terms of the Disaster Management Act. And for people to report the abuse, and I'm putting it widely, to certain institutions. So the primary concern that the court had to deal with was the validity and constitutionality and enforcement of those, looking at the judgment itself. In paragraph 84 of the judgment, the court says, submission was that there are a number of reasons why this declaratory order should be granted. And he underlines, to vindicate the rule of law and the conduct of the security forces threatens or has in fact violated the Bill of Rights. So for what purpose is this matter, am I being referred to this judgment? And then we can go to paragraph 8.
Okay. For the following reasons, my lord. Mr. Mahlangu was tortured by the law enforcement officers. SANDF members. When this matter is argued by the judge is also making reference. He's not confining himself to the SANDF only. He's making reference to all the law enforcement officers. He's making reference to the SAPS. He's making reference to the SAPS Act, the manner in which the police officers has to conduct themselves.
No, I'm not saying it's not an appropriate judgment. Simply because I didn't have the opportunity to study it before now. So when I go back this afternoon, I want to go have a read of the judgment, but I want to know what must I look for. So you've referred me to paragraph 8.
Paragraph.
And that's just stating the principle.
Paragraph 55, paragraph 57, and paragraph 55, my lord.
8, 55, 57.
Paragraph 57 and 58, and paragraph 61.
Good, I will go and have a look at it.
Thanks, my lord.
As we go along, Ms. Nkabai, what I do is I open up the cases, but I leave it on my system. So when I switch on my laptop this afternoon at home, all of them will still be here. So I can just
Thank you, my lord.
click on them.
All right.
I don't close it when I leave here this afternoon. I'm not going to switch off my laptop.
Thank you, my lord.
I'm just going to leave it open,
Okay.
let it go to sleep, and when I get home, I'll switch it on and it will be here.
Thank you, my lord. When the state witnesses who were present at sea border, when they were asked about the torture, Brigadier Anana denied knowledge of the torture. Captain Lombard denied the knowledge of the torture. Sergeant Fortin denied the knowledge of the torture. And Sergeant Johnson, they all denied the knowledge of the torture. Now I would like to refer this court. It might not be relevant, but the principle is the same, my lord. It is an inquest that was reopened in the High Court, Western Cape Division, Cape Town.
It's a well-known inquest of the late Imam Abdullah Harun.
That's correct, my lord.
Yes, I have the ruling open in front of me. It's one of the matters he wanted me to look at. That I was given a list yesterday, and I looked at it.
Thank you, my lord.
But it's also a well-known incident. In the history of the struggle in South Africa, of an incident that happened in September 1969.
Thank you, my lord. In conclusion, the state has two versions before this court. Joshlin being taken to the White Polo, Joshlin being taken to Makalima. In the White Polo, we're told that he went with a woman that is described as Sangoma, wearing a red cloth or a red dress. In Makalima's place, we're told that there was a man with a red shirt. Division of the proceeds in 204 statement was going to be done by one of the co-accused. In the story of the T-shirt, there was a story of 5,000. But this story of 5,000, my lord, is not corroborated by anyone. Either the story of the T-shirt. These are the versions that are before this court. I submit before this court that the state has failed dismally to prove its case beyond reasonable doubt, and that the defense has a right to choose if they want to remain silent. They won't ask permission from the state for that right. I'm referring this to the case that was referred by the state of Busak. I request my client not to be convicted on these charges. As the court pleases, my lord.
Thank you, Mr. Nkabai. Mr. Sivnarayan, just give me an opportunity so that I can open your documents. So I have three, besides your heads, I've got three primary cases as well.
That's correct, my lord.
Mshlongo, Malimi and Stevens.
That's correct, my lord.
No, it's just so that we're on the same page. Um, with you.
Thank you, my Lord. My Lord, I do not intend being long, but I seek the court's indulgence and request just a 5-minute stand down, my Lord, in order to get myself in order.
Certainly.
Thank you.
Certainly. It's 9:15. Why didn't we take a 15-minute break?
Thank you, my Lord.
We can rearrange the chairs. You know you're going to be on your feet soon. It's rather sooner than what you might have thought. So you can also get your house in order. And then after Mr. Sivnarayan, we'll take a short break again, and then we'll have your reply.
Thank you, my Lord.
So let's take a 15-minute adjournment just to get our systems running, and then I'll come back.
Thank you, my Lord.
Thank you. Court will adjourn. Apologies for the 3 minutes that I took from you. I had to make some logistical arrangements with the office in Cape Town about certain matters. Thank you, Mr. Sivnarine.
Thank you, my Lord. My Lord, in my argument, I've structured it in a manner in relation to the comment made by the court in my application for 174. My Lord, in my argument, I will be dealing, therefore, with the evidence of the co-accused, that of Ms. Laurentia Lombard and Mr. Stephen Kutsia. My Lord, I'd request or ask at this stage that my argument placed before the court in my 174 application be incorporated into this argument as well.
Yes.
My Lord, the test now at this stage is different from the application which I had brought in previously. The credibility of the witnesses can be considered by this court now. My Lord, I would deal with the credibility of the witnesses a little later.
Of course, the test was lower, the bar was lower.
That is correct.
At the 174 stage. So if one look at the credibility of the witnesses, if one apply the PETA test, it must be very bad before you grant the 174. At this stage, it's beyond a reasonable doubt, and all those cautionary rules that we spoke about yesterday come into play. And although there was no duty for the defense to supplement the state's case, the evidence of the statements of Mr. Apollos and Mr. Van Ryn cannot be used in itself as evidence against Ms. Smith. So what is left is what's on the other side of the fence. So that's how I have it.
Thank you, my Lord. My Lord, that having been said, I just want to submit that Section 219 and 219A of the Criminal Procedure Act is applicable with regard to accused 1 and 2, and for that reason, their evidence or their statements cannot be used against accused number 3. My Lord, I don't know if I have to go further into that or if that would be sufficient.
That's sufficient, but if you want to go further, you may.
Thank you, my Lord. My Lord, I'd move on now. My Lord, I would deal with Mr. Stephen Kutsia. His evidence was to the effect that he knew accused number 3. They came from the same area, and he told this court that they had only met on a few occasions. Prior to meeting her in August 2023, he told us that he had last seen her in 2016. He conceded that they were not friends, but they knew each other. My Lord, I submit that it would be strange for accused number 3 to say what he claimed she said to him, especially because she's not, or he's not very well known to her, and there's no bond or relationship or trust between them. He told his court that his employer, Tertia Kruger, noticed that something was bothering him and inquired from him. And he then relayed to her what was said to him by Ms. Smith. And all of this occurred during the month of March 2024. Under cross-examination, he told his court that after informing the prosecutor, Mr. Van Zyl, he was interviewed by the police, and he had explained to them what he knew. However, no statement was taken from him, and he was released from the police station. It was only, it was only in September 2024 that the state or the police officials felt it necessary to obtain his statement. Now, my Lord, my submission is that in court he told us he was quite specific about what was said to him. But I submit that what he said was not what was told to him, in that a lot of time had lapsed since the incident occurred. It had attracted a lot of publicity and attention, and he was definitely going to be made aware of the allegations and rumors and stories that were floating about regarding this incident. I say so, my Lord, because had he told the police what he told this court regarding money, a person that's going to be missing, the police definitely would have acted upon it and not just released him without even taking his statement. Ms. Tertia Kruger, her husband, and Mr. Van Zyl were called in order to corroborate the version of Mr. Coetzee and what he had reported to them. If one looks at their statements and their evidence, my Lord, Tertia Kruger, when Mr. Stevens explained the story to her and her husband, she says that all that was said to her by Mr. Coetzee was that during the month of January or February, that the area is going to look like something of a movie scene. And the place won't be known to her, or she won't recognize the place anymore, and that it would be full of vehicles. There was no mention of any other thing said to him or said to her by him. Mr. Johan Kruger, my Lord, he also testified that Mr. Coetzee said to him that he knew Kelly, that he had met her last year, and that she also said that in February, the area is going to look like something from a movie scene. And that's as far as it went. He never said to them anything about money, anything about a child disappearing, or anything of that nature. To take it further, my Lord, Mr. Louis Jacques Van Zyl, the prosecutor, he testified. And he also told Mr. Van Zyl that he knew accused number 3. Both of them were from Namakwa land, and that towards the end of last year, accused number 3 said to him that something big is going to happen, and it will receive a lot of publicity. When he was questioned, he said he was not sure exactly what was going to happen as yet. My Lord, these are reports which the witness made to his employers and the prosecutor. And that was in March already. Had he known about the 20,000 rand and that the child is going to go missing in March already, he definitely would have informed these witnesses about that, and not only told them of unimportant things like a movie scene, but the main issue about the sale of Joshlin, the amount of money, all of that would have come to these witnesses' attention. And I submit, my Lord, that because of the passage of time, and the attention that this matter got, he received information, and as time progressed, he adapted his version of what may have been said to him. And coming back to the law, my lord, I submit that he was a single witness in this instance also. Although he did relay his version, according to him, Ms. Smith is the only one who explained to him what the plan was. And for that reason, his evidence should be treated with caution. And I submit that the court should reject his version on what has just been said, in view of the fact that the witnesses who should have corroborated it do not. And there are 3 witnesses who say almost the same thing, but none of them mention the most important things about what was said to him. My lord, in that regard, I would also be referring to the same matter when it comes to Ms. Lombard, but I'd like to draw the court's attention to the matter of S. Stevens.
Yes, I have the matter open in front of me.
Thank you, my lord. My lord, this matter was finally decided in the Constitutional Court. And it dealt with...
The judgment that you referred me to is the SCA judgment.
Well, I do apologize, my lord. I did not give you the full citation.
The one that I have is the judgment of Quest Stevens and the state. Which is the other citation. I can find it quickly.
I'm just trying to see, my lord. Yes, my lord. It is a SCA decision. My apologies, my lord. The citation I have is 417/03 in square brackets 2004 ZASCA 70.
Yeah, that's the judgment of Nafsa van Heerden and Ponnen.
That is correct, my lord.
On the 2nd of September 2004.
That is correct. My lord, in this matter,
yeah,
the issue here was the evaluation of the evidence of single witnesses and the assessment of the totality of the evidence. It's a guide as to how the court should consider and look at the evidence as a whole. My lord, with reference to this matter, it is directed that the evidence should not necessarily be compartmentalized, but it should be all the evidence should be looked at in its totality. My lord, with regard to accused 1 and 2 and the corroboration between them and any that there may be with Mr. Costier, I submit that has already fallen away.
So, have you noticed something interesting in this judgment?
Beg your pardon,
have
my
you
lord?
noticed something interesting in this judgment?
Yes, my lord.
What did you notice?
My lord, it went on appeal to the High Court.
It started in the Wynberg Magistrates Court. It then went on appeal to the High Court in Cape Town.
Yes, my lord.
And who were the judges in the High Court?
You were one of the presiding officers, my lord. And I might add, my lord, that on appeal, your decision was overturned by the SCA.
No, that's right. Because we found that the magistrate was correct
Yes,
in their finding. And the SCA felt different.
That is correct, my lord.
So it's a second case that's mentioned here where I was overturned.
That is correct, my lord.
I think that the appeal was in 2004 in the SCA. And I sat with Mutala Jay, as he then was. So this would have been somewhere 2001, round about there,
I believe so, yes, my lord.
if not before that. Yes.
Yes, my lord, in my argument, I filed that this matter finds application. The court has to treat the evidence of these witnesses with absolute caution. My lord, with the evidence of the other witnesses having fallen away, I'm still going to deal with Laurentia, but with the evidence of the co-accused out, there's no corroboration with Mr. Kutsia and Mr. Paulus. I submit that his evidence, although there were not many inconsistencies, my lord, it's highly probable that accused number 3 would give him such sensitive information, especially because she does not know him so well. Information could land her in trouble or put her in the situation where she is today. Another strange thing, my lord, is 6 or 7 months before the commission of the offense, she mentions it to the state witness, but accused number 1, the person she's in a relationship and who she lives with, she says or mentions this to him only the day before Joshlin has to be delivered. It does not make sense. I submit, my lord, that, as already mentioned, that because of the attention it got, Mr. Kutsia received more information, and what he told the court could not have been what was said to him. He could not have mentioned any of the elements or the fact of cash or the fact that someone would not be found. Another interesting thing to take into consideration, my lord, is the fact that, unfortunately, it happens quite often that children do go missing in this area as well, my lord. And it's not on every occasion that it becomes or that it receives so much of attention. Sometimes children go missing within a week. They found most people not even aware that it actually happened. So it's strange, my lord, that in August already, my client would have had an idea that something like this is going to bring so much of attention. How would she have known that a common thing or something that is not an isolated incident, something that happens in the community, that only her matter, when it happens, would cause such a big stir and such an interest in the community? That is also strange, my lord. I submit he may have met accused number 3, they may have had a discussion, but it's very unlikely it is what he said to this court, my lord. And applying the cautionary rule, I submit that the court on that basis cannot accept his evidence at the risk of a false conviction. My lord, on Stephen Kutsia, that is all the submissions I have, unless there's something the court wishes me to deal with regard to his evidence.
Except, of course, in in Koos Stevens, the magistrate made the factual findings on the basis that she attached less weight to the purported contradictions because of the language issue. The witnesses were Xhosa speaking and the statements were taken in English. And we then confirmed that. We said, well, the magistrate made that finding, trial court. But applying the cautionary rule properly, a la Sols and the other authorities, the Supreme Court of Appeal was correct in overturning us. Because we should have found that the magistrate should have been more cautious, and we didn't. So on the application of the law, it's a good point to make that one's got to be super cautious when one deals with these issues. And that's the legal position.
Thank you. And for that reason, I asked that this court exercise its extra caution in deciding this matter, my lord.
On a serious note, we spoke about the Lubatka case the other day. There it was placing a person on the defense on some of the charges where there were confessions of co-accused, which is applicable here. I was overturned there as well. That was my very first case on the bench. As I said, it started on the 17th of September 1999. And Stevens was also a few years later. But one must have regard to the caution of the higher courts when one considers these issues. So I take your point, and I will, to the best of my ability, go and sit and look at it and take guidance from the authorities of the higher courts. That is why I've tried to impress upon counsel, give me authorities that's binding on me so that I can take the guidance.
Thank you, my lord.
Thank you.
My lord, I would now like to move on to Ms. Lombard's evidence.
Are you going to, because you've now heard the argument from the state, are you going to deal with their timeline at all? I just want to know whether I should open it, or you're just going to touch on it as you go along.
My lord, I'm just going to basically deal with contradictions. And my lord, with regard to timelines, there's been lots of uncertainty with regard to timelines in this trial. And I submit that one of the contributing factors is the use or the consumption of drugs, my lord. It must be borne in mind that at all times, that all incidents that were testified about, Ms. Lombard as well as the accused were all under the influence of drugs.
And Ms. Lombard indicated that the effect of the substance stays in her body for a prolonged period. But it was also that, forget about the fact that she was already using for about 16 years at the time of the event, but during that period, let's say February of 2024, she says 2 to 3 times a day.
That is correct, my lord. And even when she was explaining the discrepancies in her confession, which she had made, one of her excuses was that she was not in, or her mental abilities or mental faculties were impaired, and that she was not in a sound and sober senses. That is why she made those errors. And on her own as well, she told this court that she consumed drugs on the Sunday and the Monday of the incident. My Lord, for that reason alone, based on what she told this court, she confirmed that she was unreliable when she consumed drugs. My Lord,
And as you indicated, it doesn't only apply to her.
Yes, my Lord.
It applies to your client as well.
Yes, my Lord. That was the point I wanted to make, that there could be a discrepancy in the timeline because of the use of drugs. And it came out during this trial that not many people had cell phones and watches in the area, my Lord. So that could make it more difficult for anyone to actually estimate or give us a time.
In fact, Ms. Lombard had no reference to time, but for the starting time and lunchtime of Ayanda. And when some of the helpers would come and collect stuff. And
Yes,
although I saw on one of the photographs, the second set of photographs that shows the inside of the house of Ms. Smith, of your client, there was in fact a clock on the wall.
Yes, my Lord. And I submit that for the reason stated, no one, neither Ms. Lombard or the accused, should be faulted for their incorrect times which they may have placed before this court. My Lord, Ms. Lombard was well known, or is well known, to the accused and accused number 3. From her evidence, they were good friends. She always went to accused 3's home. She always got food for her children from accused 3.
Well, you had put a statement to Ms. Lombard about the relationship between Ms. Smith and herself, that it was such that if your client had something, she would share it with Ms. Lombard, which she confirmed.
That is correct, my Lord.
It was also a place that she could go for sustenance for her children.
Yes.
The impression I gained was that of the 4, and I'm talking about the 3 persons that's accused here and Ms. Lombard, except for the odd selling of an item, second-hand item, or the fixing of a cell phone by Mr. Van Rijn, and then on selling it, or Mr. Apollos now and then going to clean somebody's yard, or assisting Ayanda at the car wash. The only one with a regular stream of income and or provisioning for foodstuffs was Ms. Smith, because she was working every day and ultimately feeding their drug habit as well, because she had to go out every day. We heard the evidence of the Zegers family. Early morning, go and work, come back. We know, and I'm not casting any aspersions on persons using substances. It's an illness, and once you get addicted, it's very difficult. But she was the one that was looking after them in a great way. And of course, Ms. Lombard had the assistance of Ayanda as well. But when it came to a regular stream of either income and food, Ms. Smith was the one. So it seems from the evidence.
Yes, my Lord, and from the way the matter or the events unfolded, and if one has to look at Ms. Lombard and her behavior, my Lord, one could almost say she's an opportunist. My Lord, as correctly mentioned by the court, she was able to sustain and support her children through the assistance of Ms. Smith, and she took advantage of that. According to her version, she was promised money by Ms. Smith, and she went along with that, bearing in mind, my Lord, that she is a mother as well, and she has children of her own, at least at that stage, maybe 4 children.
Of which 2 were with her.
Yes, and She submitted to this court that when she was told about money, she agreed. And she was happy with that. Again, my lord, she was going to gain from this, so she had no issue with it. She stuck to her version to keep quiet, according to her, because the money was still promised to her. When she realized now she's in hot water, the money is not forthcoming, and there's a very good likelihood she's going to prison, she decides to turn. She throws her friend under the bus, and she decides to talk. Again, an opportunity for her to save herself. And my lord, for that reason, I submit she would have said anything in order to distance herself and implicate another person so as to save her own skin. My lord, there were many contradictions in her evidence, material contradictions. And because she's a single witness, only one material contradiction is sufficient for the court to reject her evidence as false, being a single witness, if there's no other evidence to corroborate her.
That's where I want to go, because particularly insofar as it relates to your client, the state argues and concedes that there are portions of the evidence that I can't find reliability because it's not corroborated. But then they go further. They say, well, there's this so-called golden thread, a la Miss Swanepoel. And there are the touch points where you find corroboration for the evidence. And if you then take only the portions that are corroborated and you have that warranty of reliability, which is also a term that one must be very careful with. In Chris Stevens, you would have realized from the Supreme Court of Appeal judgment that my judgment, that was the appeal from the Magistrates Court, was in Afrikaans. Because they used the term getrouheidswaarborg, where I indicated the magistrate found that the language issue not so important to break the chain, if one could call it that. So, if one look at those touch points as the prosecutor has pointed out, what do you say about that?
My lord, just before I deal with that, before I forget, I just want to mention that Ms. Lombard had many opportunities to come clean. She on her own requested to speak to officials in order to speak the truth, but she still failed to do so. When she came to court, in court she was given the opportunity to speak the truth, but she was caught out in her lies in court as well. I submit that she lied throughout, even when she was given the last opportunity to speak the truth. She still never take the court in her full confidence. My lord, with regard to the corroboration or the golden thread as it is now, as I've already submitted, there was a link between what was said by Mr. Paulus in his exhibit and Ms. Lombard. That falls away now, my lord, because his evidence cannot be used against her. And I submit...
No. That's not the state's argument. The state's argument is, yes, we concede the evidence in the statement of Mr. Paulus, which is admissible against him, cannot be used against Ms. Smith, but it can be used to provide corroboration for Ms. Lombard, and then Ms. Lombard's evidence will then count against Ms. Smith. Let's just go to the so-called discussion on the Sunday of the 18th, where she said, I'm going to do this. Now, he says in his statement, Mr. Apollos, a discussion took place in the statement. Now, how I'm going to deal with the difference between the Friday and the Monday in evidence, that's a debate for Friday. It's a debate in my mind tonight and tomorrow, on which I will pronounce on Friday. Because you will recall when he didn't testify in the main trial. The statement is admissible against him as evidence, against Mr. Apollos. And the attack on the statement was twofold. One was the prerequisites. Second issue was the content. Now, Mr. Harmse takes him through it on the Friday, sentence by sentence. And you will recall that when the evidence was presented, Mr. Harmse wanted him to read it quietly to himself and then tell us where it would part ways between his own ability to compose a story on the fly and what was told to him to say. I then intervened and I said, no, let's take it sentence by sentence so that there's no confusion. That whole run-up on the Sunday, no, it's perfect. That's the truth. That discussion did take place. That was his evidence. Of course, I've posed the question during the evidence when he flipped on that on the Monday, whether the fact that Ms. Smith was not physically present in court on the Friday played a role to the Monday, because remember that's the day that she had the medical procedure. But then he doesn't come in the main trial because now I admit the evidence against him. Boom, it's in. Doesn't come and disavow it. So the state can utilize that evidence against him. That's right. But it's also evidence in the bigger scheme of things, in the totality of evidence. Now she says, Ms. Swanepoel, she says, what are the chances of it not being true? When Ms. Lombard says she overheard a discussion. Now remember the finer detail of the wording being used, that's another issue you've told us in your argument. These people were high on drugs and there will be discrepancies. And she says, there's my warranty for the reliability. What are the probabilities that you would make it up? It's 0 because he himself says it happened and Ms. Smith was in that room. Boom. So on that score, that's how they want me, if I understand the argument, that's how they want me to deal with it. Now, can you counter that type of argument?
My Lord, I cannot make a finding on the credibility of accused number 1.
No.
However, with regard to Laurentia Lombard, I submit that she straightforward just lied to this court, my Lord.
No, I'm just asking you about that portion of the evidence, because that portion of the evidence can be the key to the final findings the state says, because the state says, you find Laurentia Lombard reliable on this issue. because of the confirmation. Then you have the plan, she says. And from there onwards, the execution of the plan goes in different directions, according to Ms. Lombard, to the Polo, Mr. Apollos, and I'm just referring to Mr. Apollos now, to Makalima's house. But the point is, she mentions the 20,000, he mentions the 20,000. There was the plan, both mentioned the 20,000, so there you find your warranty of reliability for the money. It's common cause. Joshlin went missing that day. Prosecutor says, I don't even have to take you further, cadre question. End of the story. Yes, there are lots more, but what do you say about that argument? Because it's now not using Mr. Apollos' statement against Ms. Smith. It's merely using Mr. Apollos' statement to bolster their evidence. That's what she says.
I do understand what the court is asking of me, my lord. However, I submit that in the fashion which my colleague is asking that the matter be looked at, it would then infringe upon the accused. It would still have the effect of using the statement or what was said by the accused against her. Because although the court has to look at all the evidence in its totality, each witness also has to, their evidence has to be scrutinized as well, my lord, and then everything looked at in its totality. And if one has to do that, and especially with Laurentia Lombard, considering all the material contradictions, inconsistencies, lies in his statement, evidence is so poor that it cannot be relied upon, so there's no need to actually find corroboration for that evidence because of the poor quality of the evidence. I think my submission is that once someone looks at her evidence on its own, it is so poor that there's no need to find corroboration.
You may proceed. I'm just going to pull up a judgment, but you may proceed.
My lord, it must also be borne in mind that when Ms. Lombard made these statements or confessions, it even came out that there were promises made to her, or she expected to receive some benefit, and that's the reason why she did that. Again, that points to her being an opportunist or only looking after her own interests. Even the issue regarding the broken window, my lord, that is material. That relates to the actual hearing of the plan or what was going to happen. And the court will recall that. The court even asked Ms. Lombard if the breaking of the window then makes it easier for you to have heard what was said between accused 1 and 3. My lord, I submit that was made up. And the reason why that could have been made up is because if Ms. Lombard did not hear this through the window, and if it did in fact happen, she then would have had to have been present during this discussion and planning and be directly involved. My lord, when caught in a lie in court, she then opted not to answer the questions, and I submit that this happened many times during cross-examination. the state is asking us to rely on her evidence, my lord. And being a single witness, I submit that the cautionary rule should be applied, and her evidence and that of Mr. Kutsia being single witnesses does not satisfy the cautionary rule. There's no corroboration which the court can consider. Common purpose, my lord, it would have only been Miss Lombard, who I submit would have been able to prove that element, or that there was common purpose. I submit in that regard they have failed. And my lord, the fact that initially, as indicated, the state is asking us to accept the version of Miss Laurentia Lombard as that of being the truth. But we still have the evidence of Mr. Apollos. Now, as we stand, there are two conflicting or mutually destructive versions which are before this court, and both these versions were placed before this court by the state. Now, being faced with two conflicting versions, that on its own is a clear indication that the state has failed to prove its case beyond a reasonable doubt. Because immediately the question arises, if we have to say they are guilty, guilty of what, my lord? That accused number 3 took the Joshlin to the car, or did accused number 1 take Joshlin to Makalima? So already, as it stands, the state has failed to prove its case beyond a reasonable doubt. And those are my submissions, my lord. Unless there's anything else the court wishes me to deal with.
What do you say about her comment on the Busa case? Because remember, it goes slightly further. Ms. Lombard gave a version as to what happened, and then she says, well, a few days later, I've also spoken to her about it, I think it was the 23rd, about the money. And on that score, she was quite consistent. Or do you throw everything in the same pot by saying, well, she's so bad that nobody should believe her?
Yes, my lord. That's what I do submit, because she has every reason to lie. My lord, as mentioned, had she been making mistakes, or she intentionally misled this court, she wanted this court to believe that she played a very small role in the commission of this offense. She tried to really water down her role in this offense. She tried to make it seem as if throughout the entire process, she tried to approach accused number 3 to convince her to change her mind. And then even in court, she says that in the presence of the policeman, she told Kelly to tell the police what happened. And that was a clear lie, my lord. It's clear in anything that she did throughout this trial, she just tried to save herself and only what would benefit her.
This was the portion I was looking for by the words used by Williamson J. in PETA, where he termed it that the evidence is of such a poor quality that no reasonable person could possibly accept it.
Yes, my lord. My lord, taking everything into consideration, all the evidence produced even there is a lack of corroboration, even the court finds that there is some kind of corroboration, I submit that even that does not prove the case against accused number 3 beyond a reasonable doubt. Those are my submissions, my Lord.
Yes, thank you, Mr. Sivnarayan.
Thank you, my Lord.
Are you ready? You want to take a short adjournment, or you ready to shoot?
I'm ready, my Lord.
All right, so you've heard the arguments on behalf of all 3 of the accused. Time for reply.
Thank you, my Lord. Perhaps let me just start here at the very last remark. And I don't really think that anything that I'm going to say today is going to make any difference. I think...
What do you mean?
I think, my Lord, you have heard everything. You know exactly what the evidence was and is. And you have referred us to the case law and all of the cases. It's all there. I do not want to be in your shoes, not at all, not for a second. But I know that all of this is in capable hands. But if I can, in some way, try to assist.
Compliments aren't going to buy you any favors.
I know. I'm not even trying.
No, that's just an enlightenment. It's wonderful. We've had...
no, of course.
We've been working around the clock, so...
Not at all. My Lord,
and all of you have brought your part. I've indicated this morning, Ms. Nkabai sent heads of argument at 19 minutes past 3 this morning.
We have had little sleep, my Lord. I think we are all tired. I think we are all drained. But I have to just remark, on the last that Mr. Sivnarayan has just said, about Ren's having everything to lose, and that she would tell the police, or tell Kelly, tell the police what you did. You know what you did. She's not the only one who did that. My Lord, we need to also remember that it was Captain Lombard and Fortuyn's evidence that both accused 1 and 2 did exactly the same thing. They also said, Kelly, you know what you did. Tell the police what you did. So we've got 3 people in this planned agreement that do exactly the same thing. They all point the fingers to Miss Smith. Now, my Lord, I have made our submissions that Miss Lombard, yes, I concede, she wasn't the best witness. Definitely. There's criticism. There can be criticism. I set that out in the heads and yesterday, and I concede. But, my Lord, when one applies the test, as in the Mpeta case, then that evidence must be so bad that no reasonable court can believe it. And my submission is, that's not the case here. Not at all. Because we are not solely relying only on her evidence. We find the corroboration for her version in all of the other evidence. And yes, my Lord, you might differ from us and say, no, that is not corroboration enough, or that's just argument. But we made our case. We tried to show exactly where we find those little puzzle pieces, to piece it together to find the picture, the puzzle at the end. My Lord, I submit with respect that if it had only been Miss Lombard's evidence, it would have been a problem. But it's not. Mr. Kutsia, in my respectful view, was an excellent witness. I don't think there can be any criticism against him. And his evidence wasn't really challenged. And he was corroborated. And my Lord, let's just use the common sense principle. as...
So let's, if we disregard Laurentia Lombard, for now, for argument's sake, going back to Mr. Coetzee, you'll have the following. Mr. Coetzee meets Ms. Smith at this service. I don't know what you call it, troostdiens in English. And in the manner that he puts it, and how he pronounces it. It gives another meaning to it.
Yes.
Having seen Mr. Coetzee. So they hail from the same area, the general area in the Namakwaland. Sees her now and then. She asked him to find a job because he's also doing day work in Jacob's Bay at people's houses, same type of work that she does. But they don't see each other that regularly, and he then tells us about what happens that morning. Now, again, he's a single witness, and although being cross-examined, evidence is not gainsaid. Not gainsaid at all. But one can find comfort in the reliability of his evidence from objective observations of the area in the inspection in loco. And I'm not saying this is a finding. I'm thinking aloud on your case. By pointing over the shoulder across the blue house, and that's the house in front, not the one where the woman was scolding everyone, the other one in front. Because I asked at the inspection, were these houses here at the time? And I was told it's the blue one was there. And if you then follow that line, it's pointing to her house. Now, he didn't know where she lived. It confirms a meeting at that spot. There's, of course, the coincidence of how she was dressed and the description of what Joshlin was wearing when she went missing, but nothing is made of that. Then she relates a story to him about the unhappy family life, and that the children will be leaving early in the new year. Let's forget about Laurentia Lombard now. Then there's the discussion a la Mr. Apollos, which is not evidence against Miss Smith. Keep that in mind. It's about the unhappy life and the child. Joshlin must go. Then she's gone. Then you have the conduct. Will that be sufficient to draw inferences, to invoke the Busak principle?
Absolutely.
And I've taken Laurentia out of the picture for now.
Absolutely, my Lord. And having said that, may I thank this honourable court, but also refer the court to the case of Reddy, Because isn't that exactly what happened in this matter? There the court found that the eyewitnesses' evidence was not reliable enough. So let's discard the eyewitness and only go on the circumstantial evidence. And even then, based on the circumstantial evidence, it was enough.
I see you flagged your copy. Do you want to refer to any portions of the evidence? Maybe just put the reference on record as well of the case.
My Lord, if I may...
That's the one you found on the internet, or the one that we uploaded?
It's the one that was found on the internet.
Okay.
My colleague
No,
found
because
it.
you wouldn't have had access to the law report because
No.
it's not on SAFLI.
No, my Lord, I have my colleague to thank for that. Thank you. So may I please then
Yes,
refer you
okay.
to page 20 of the decision. In assessing circumstantial, and it's halfway on the page, in assessing circumstantial evidence, one needs to be careful not to approach such evidence upon a piecemeal basis, and to subject each individual piece of evidence to a consideration of whether it excludes the reasonable possibility that the explanation given by an accused is true. The evidence needs to be considered in its totality. Then the court refers to the Blom decision, of course, but may I also refer to where the judgment refers to Lord Coleridge in Rex versus Dickman.
So that's the judgment of Zulman AJA as he then was.
That's correct.
And who were the other two judges?
Smalberger and Howie. On page 22, he refers to the Rex versus Dickman case. And it starts off, and I'm not going to, I won't waste your time, my Lord, but please allow me. It is perfectly true that this is a case of circumstantial evidence, and circumstantial evidence alone. Now, circumstantial evidence varies infinitely in its strength, in proportion to the character, the variety, the cogency, the independence, one of another, of the circumstances. And then I skip a part and I go to page 23, the last bit of that same portion. The law does not demand that you should act upon certainties alone. In our lives, in our acts, in our thoughts, we do not deal with certainties. We ought to act upon just and reasonable convictions, founded upon just and reasonable grounds. The law asks for no more, and the law demands no less. My Lord, my submission is, even if, and this is only with regards to Ms. Smith, because yes, we're alive to the fact that the confessions or the statements and the contents is not admissible against her. But Stephen Kutsia, corroborated by the reports made afterwards, his demeanor, his character, there is no way that that man made this up and fabricated this. My argument is, my Lord, there's absolutely no way that he would want to put himself in this position and come and testify about this. Why? There's just absolutely no ground for an argument that that was a fabrication and seek of fame. The person seeking the fame was Miss Smith, definitely not Mr. Kutsia. My Lord...
Well, what are the probabilities that on the 5th, now, let's take Mr. Kutsia's evidence. It says on the 3rd of March, he wasn't aware who the parent was of this child, that the memorial was, or the prayer service was being held. But he goes. Community event. He's also an evangelist. He goes.
Of course.
He sees this person
And he leaves.
with the red, pink clothes. And she goes up to the stage and he says, my word, maybe he used a stronger word in his head. But
That's that woman.
that's the woman that spoke to me. That's Kelly.
Exactly.
That's my home son.
Exactly.
Or my homie, I think he said homie.
Homie.
That's my homie. And he goes home and he tells his wife, this is his evidence.
Yes.
Goes home and he tells his wife,
And she says,
with whatever he refers to, he says, he won't believe it. She told me. She says, don't get involved. She says, this is going to be high profile. You don't get involved. He's a blood man's. Now that's a third. For the first time he has to go to work again is on the Wednesday the 6th.
yes.
He's totally unaware of what had happened on the 4th and the 5th. Doesn't know that. But as they say in Afrikaans, wonder bo wonder. On the morning of the 5th, Mr. Apollos spoke to Captain Pretorius and relayed a very similar story.
Exactly.
He doesn't know Mr. Apollos. Mr. Apollos doesn't know him. And then he goes on his trip to Jacobs Bay on the 6th. And I've heard argument about, well, they didn't take a statement, etc. But we heard Mr. Van Zyl. It wasn't news to him. Because he, so happens, is the control prosecutor in Vredenburg. Because he says, well, we already knew that. So, going back to the debate the two of us are having now, what happens? Will that be enough to have called upon an answer from Ms. Smith? I'm not saying you impute anything, but in drawing the inferences to say, but this was calling out for you to come and tell us that you never spoke to Mr. Coetzee in that way, and you didn't.
Yes. Definitely, my lord. Definitely. The only thing that was put to Mr. Coetzee was, didn't happen. I didn't have this conversation with you. How is it possible that he would have known all of that? And I submit, that's not the only thing. There's so many other pieces.
No, you've taken me through that yesterday. Yes, is there anything else that you want to deal with in reply?
My lord, if I may, the case of Komane, I thank you. This is a case that I will never forget. One learns a lot, even in a trial. This decision, and more specifically so, my lord, if I may, the bottom of page 9, it's paragraph 20. One must bear in mind that the cardinal rule is whether on the conspectus of the evidence it was established beyond a reasonable doubt that the applicant committed the offences. It's unacceptable that any possibility, no matter how far-fetched, should be elevated to a defense in law. And coupled with that, my Lord, the last 2 pages of this decision deals only with Supreme Court of Appeals judgments, except for Busak, of course, which was a constitutional court. But in this last 2 pages, the Honourable Judge then deals with circumstantial evidence and how it should be evaluated. And
it deals with almost all the Supreme Court of Appeal authorities. Absolutely. And the Constitutional Court. That forms part of our argument here.
Exactly, my Lord. And you are well aware of this because you referred us to it. And I'm thankful for it. And that's why may I just refer to what is contained in paragraph 34 when reference is made to the Shabalala decision, well-known decision, where it refers to what was said in the old matter of State versus Mtetwa, 1972 case, where there is direct prima facie evidence implicating the accused in the commission of the offence. His failure to give evidence, whatever his reason may be for such failure, in general, ipso facto, tends to strengthen the state case because there is nothing to gainsay it, and therefore less reason for doubting its credibility and reliability. So, and just to take us back to the argument about Mr. Coetzee, and yes, I've flagged it because all of those decisions are relevant, but Mr. Coetzee's evidence is another high water mark, and there's nothing, if we're specifically speaking Ms. Smith now, there's nothing to gainsay it. There's nothing against that.
No.
There's no version.
No, that's the direct evidence of Mr. Coetzee,
yes.
Indicating what Ms. Smith had told him.
Yes.
But we heard a lot of evidence about conduct,
yes,
by Ms. Smith and the lack of conducting herself in an expected manner during the period 19 February till 4th of March.
Indeed.
And that evidence was presented by the state.
Yes.
What weight, firstly, do I attach to that? Because it's human behavior.
Yes.
What inferences do I draw from that? And does it make a difference that in the broader conspectus of the evidence that it stands unexplained?
Definitely, my Lord. I think it screams out. If you were to consider all of those little pieces of evidence, behavior, the number of times she told the number of different people that my child Joshlin has made me famous. It screams out that she needs to come and tell this honourable court, what happened. But she doesn't.
But remember, she's not.
I know.
She's not asked to. This case is not about where is Joshlin.
No, it's not.
This case is about them being charged with a criminal offence,
Yes.
or criminal offences, plural.
Yes.
And the state bears their honours.
Yes, definitely.
And there's no duty on the defence.
Absolutely not, my Lord. But if everything is considered together, all of this, my submission is, then there's a call on her to answer to it. If not, that prima facie evidence becomes conclusive. And that's what the authorities say on it.
Thank you.
Thank you, my Lord.
All right, so I am going to give the judgment on Friday, coming 2nd. I take it there will be a lot of people coming to court on that day. So we're not going to start at 8:30. (9:30), will that suit the parties? Let me just hear, there will be, or should we start at 10? There will be logistical arrangements to be made, especially if the hall is going to be full. So the police outside will have to do their work. And I'm going to make a specific ruling as to seating arrangements now. So maybe we should start at 10.
I think at 10, my Lord. It's also the mist and many people travelling, I think 10.
No, but I suspect, the media would maybe come with more cameras and stuff like that, so that they can set up in time. If I start at 8:30, we know what happened the last 2 days, then I want to be left alone here, setting up my own system, and we can't really operate. So we're going to start at 10 instead of 8:30, and just for the public, 10 is the normal starting time for the High Court. We've just made up time by starting earlier. Mr. Pollis, Mr. Van Ryn, Ms. Smith, I want you to provide, before you going back to your accommodation for tonight until Friday, your legal representatives with the names of individuals that you know will come to court and attend court on Friday, so that we can arrange for them to have preferential seating. And the same applies to the state, so that you can then provide those names to the SABC officials on duty. So if, for example, there's a family member that comes, or from the state, I don't know about, and I don't really care about it, about dignitaries, I don't think they should be treated differently. Unless, of course, it's a security issue. And I'm not going to make that call. Because I'm aware that when the matter appeared the first time in the Magistrates' Court, there were a lot of dissatisfaction from the community because high-ranking politicians had filled the room. It turned out to be an event outside court that I saw on television, nothing to do with the merits. Barbed wire and things like that. We don't want that. But of course, there may be certain concerns. There may be issues that, because of the profile of the case, that, say for example, the Commissioner of Police want to attend, the Provincial Commissioner or whatever, then there are security issues around it. Or a minister, and I'm not talking about Minister Mackenzie, I'm talking about other cabinet ministers maybe, or so. I will not get involved in those arrangements. For me, anyone that attends court is equal. But I'm aware there are concerns. Only exception I'm going to make is the family of the deceased, of the accused, and we always do that in high-profile matters, but also in the murder matters that we have in the High Court, and that's where the slip of the tongue came in, because I always want the family of the victims present when I deal with the matters. So the first two rows I think we should reserve for those exceptions that we're going to make. So it's the family members. We might want to make provision for if there are people that's less abled or challenged in a particular way, so that we provide that space. I'm also aware that there were a lot of people that were here every day of the proceedings. And I'm expecting an influx on Friday. If arrangements can be made, and I'm sure there was cooperation between community groups. Often in the mornings I would see the Community Policing Forum members with their pubs outside, working outside with the public. Arrangements be made that we don't exclude those that have come every day for the last 8 weeks. We try and accommodate the people that were here and were following. The current seating arrangement is for 200 inside the hall, and that's the area down there. I am not going to make a ruling on limitation of numbers because I don't know the complexity and the ability of the law enforcement agencies and this whole evacuation and those type of things. But I have spoken to the colonel in charge when we had the break, and I indicated to them I will abide by their operational plan insofar as it relates to the numbers and so forth. I'm sure something will be put in place. Anything else, Swanepoel?
Nothing, thank you.
Mr. Harms, sir.
Nothing, Madam.
Mrs. Kabai? Mr. Sivnarai? Okay. So Friday morning, 10 o'clock, we will resume. I will then, I won't have a written judgment. I will have notes. And I will give my judgment. And then the normal court process will follow. We will adjourn. And I will make an announcement in the morning about what I expect of the conduct of everybody concerned. Because when I have the experience in these type of matters, that either way the judgment goes, you will have ululations and clapping and or disgust being shown, that we keep the decorum of the court. I expect everybody's cooperation in that regard. Right. Just to the media, I know that sometimes when I adjourn, you film in the area. I'm going to give you about 15 minutes or so because I need to come and pack up. I need to pack up my equipment. So I'll give you about 15 to 20 minutes before I come back in, because I'm going to change and then I'm going to come and pack up because I need to take everything with me. but don't get me on your live streams. Thank you. The court will adjourn. Sergeant, I'll get your warrants for you ready in a moment. Mr. Apollos and Van Rijn, I didn't tell you going back to Malmesbury, and Ms. Smith to Langebaan. Court will adjourn.